All right, it's 101 down in Vegas. Are we about ready to start? Give me hand signals.
Yes.
Okay. Are we ready technology-wise? Okay. It is 1:01 p.m. on October 20th, 2017. This is our publicly noticed meeting for Child Support Guidelines Committee, and I'm going to call the meeting to order, and we will do roll call next. Let's start with Kathleen Baker.
Present.
Click your mic.
Present.
Karen Cliff.
Present.
Ellen Crecilius.
Present.
Senator Farley. Assemblyman Fumo.
Present.
Judge Hoskin.
I'm here.
Nova Murray.
Present.
Assemblyman Pickard.
Here.
Judge Robb.
Present.
Senator Roberson. Joseph Sanford.
Present.
Judge Shirley.
Present.
Justice Stiglitz. Kim Surratt, I'm present. And Don Throne.
Here.
All right. Let's move on to the next item on the agenda, which is public comment. Do we have anybody in Carson City that would like to give public comment? Seeing none, do we have anybody in Las Vegas that would like to give public comment?
No one.
No one? Thank you. All right, agenda item number 2.
I'd like public comment.
Oh, okay. I didn't realize we had somebody on the phone. Go ahead.
Okay.
You have 3 minutes to give public comment. Please make sure you announce your name before you start.
Okay, my name is Melissa Porter, and I have not been following this. I actually just found out about this committee, and my concerns with the child support issue is something that somebody close to me has been dealing with, and currently has a case pending in the Supreme Court on this matter, is where it's a 50-50 custody arrangement, and they only require the so-called custodial parent to complete, or the non-custodial parent to complete, their employer to complete the financial information and employment history, salary stuff, and all that. And the problem that this person had was the quote-unquote custodial parent continued to lie to the district attorney about her income, and this has been going on for a year. It's still pending in the Supreme Court, and what my concern is what protection non-custodial or other parents have against the custodial parent and what their income actually is. And my also concern is how come retroactive modification isn't the same across the board and implied or considered upon the actual request for when the request for modification of child support is filed? And that's it.
Okay, thank you very much. Do we have anybody else on the phone in Carson or in Las Vegas that would like to give public comment? Seeing none or hearing none, we're going to close agenda item number 2 and move on to agenda item number 3, approval of the meeting minutes from September 26th, 2017. Do we have a motion or comment on that? And I will comment that amended minutes were sent out, and that is what's available today with the edits that were grammatical.
Keith Pickard for the record. I'll move to adopt as amended.
Second.
Okay, with a motion and a second, any further discussion? Seeing none, all in favor say aye.
Aye.
Anyone opposed?
Aye.
Okay, motion passes. Agenda item number 4 is discussion of the recommendations detailed in Exhibit 44 of the 2015 written report of Jane Veneral, PhD, to the state of Nevada. Agenda item number 4, that is actually just the title. We have subcategories under it for our agenda, so we'll move on to the first one, which is 4A. Discussion and recommendations as to what formula to use for child support after elimination of the presumptive maximum amounts pursuant to items 2, 3, and 5 of Exhibit 44, and the action items from the September 26, 2017 meeting. And then we have that listed for possible action today. Does anybody want to start the discussion on this item? Nobody wants to start the discussion. Okay, so as we stated in the last meeting, these items, we decided to go ahead, we made a decision that we weren't going to have the caps, but we still had to discuss an actual formula for replacement, and we decided we need to dig deeper into this. Wisconsin was utilized as part of the model that we were discussing using for replacement of those formulas or adjustment of the current formulas that we have. Does anybody have a recommendation on where we need to start in order to make this replacement?
Judge Hoskin, for the record, I think in this analysis we'd probably be better served if we make a determination as to whether we're going to utilize the percentages that we have currently, if we're going to utilize different percentages, and then I think from there we can probably move forward and make a determination as to whether the percentages change on the high end or on the low end with self-support issues. But I think if we're looking for a place to start, I would suggest that's where we start.
Additional recommendations? Okay, I will comment that within the guideline review that was done, there were, if I could get everybody to move their attention. Let me find the page. Where this recommendation was, it was on page 84. And one of the recommendations on how to deal with this, if we look at number 2, it was review the premise and basis of the Nevada Child Support Guidelines and other state guidelines in Section 2, identify and review supplemental information if appropriate. I feel that we completed that in our last meeting. That number 3 says to determine whether the base guidelines percentage formula should be changed, that the how is to review the economic evidence on child rearing expenditures in this report in sections 2, 3, and 4, and new studies of child rearing expenditures as they become available. If we flip then to page number 11, try to get us going here. The economic expert put it in Exhibit 6, major factors and assumptions underlying state child support guidelines and what their models are. And she's got comments in here about assumptions regarding child support rearing costs, economic data on the cost of raising children, and what the guideline models are. Showing what Nevada is versus other states. And I think my personal opinion would be that one of the major problems with our child support, as you move up the scales to the higher income levels, you're seeing a disparity where the lower income brackets are completely unfair versus the higher income brackets. We're not seeing equality between them. Part of that comes back to the child rearing costs and where states are getting their numbers. When I looked back at Wisconsin, I'm still a huge fan of what Wisconsin has in its statutes and its formulas, but I'd like additional input from this committee. If we're not prepared to quite make a recommendation on this yet, because no one's done the research, which may be the case, for us to break it down even further for items 2, 3, and 5 of Exhibit 44, then say it. Testify as to that, and we'll give people more time to research that, because it really is a big leap.
This is Keith Pickard for the record. My feeling on this is that I looked at what was included in the study, and it's not really detailed very well in terms of what those economic data and where it's driving, at least to the point where I felt comfortable understanding what is the right number, the right child support amount. I agree that with the caps and you end up with someone on $1 over the threshold pays more than the person with the $1 under the threshold, that doesn't seem to be fair. But what I was trying to figure out was, do the percentages actually make sense? And if we're going to, and I certainly support the idea of coming up with that personal reserve amount, as the beginning point at which we start paying. But to me, I wasn't convinced that 18% wasn't too much at the higher levels, right? Or 25 or 29, whatever that may be. So as the income goes up, we would see a substantial increase to the amount of average child support paid. So I don't know that the information that's included in the study is really enough for at least me to get comfortable with the idea that the 18% or the 25% is the right percentage of gross income if we're looking at this in terms of what the average person would pay in child support. That said, I recognize that we have a lot of statutory inertia, and I'm not suggesting we necessarily change that. I'm just saying that I'm not comfortable with what we have in this document so far in terms of making that determination.
When I look at this, it brings me back to, we have high percentages because then we have the presumptive maximums, the brackets that bring us back down to a realistic number. Not only do we have the percentages set that way, but we're working off of gross because the concept is it's going to drop down after the fact based on those maximum brackets. So we'd have to come to a percentage. We either have to come to a percentage that makes sense without having to use the brackets to jump back down to a reasonable child support amount, or we have to do what some states have done, and what was in the guideline review was about a lot of states take gross, but they still take taxes into consideration. Well, I think we're taking taxes into consideration by using the presumptive maximum brackets, but then our brackets aren't coming up with fair child support amounts for high income versus low income. So I'm in favor of taking first steps of things such as, yes, we calculate off of gross income, but maybe it's gross income minus at least taxes, federal taxes that we know people have to pay. I mean, Nevada, we have the benefit that we don't have state income tax, so it makes our lives a little easier on the calculation. Once you do that and you look at our percentages weren't that far off from Wisconsin. I remember the one child number being 17%, right? 17. So for one child, they're 17%, but they're, what they get to what they calculate it off of is what's the more important part, I think. The same concept goes with childcare costs. We're a deviation factor for childcare costs. We're trying to get away from deviation factors because the federal mandate is to have fewer deviations. So if the calculation is on the front end with child care, we don't know if our numbers with 18%, for example, is going to turn out to be a reasonable amount till we know what we're taking off of the top in that calculation, I guess is where I'm getting with this. I don't know that our brackets, if you took somebody's income and you deducted their taxes, and then you did 18%, how far off are we from our maximum income brackets that we have right now? If that makes sense, where my confusion comes from on our math and our calculations.
I understand the concern about the adjustment for taxes. My problem is the gamesmanship that is inherent in that almost immediately. So you are the payor parent. You're going to maximize the taxes that you pay with the understanding, hey, I'll get a big refund at the end of the year. If I take no deductions, I don't do anything, I pay the max. That way I limit my child support, but I'm still getting the money back. I've got a problem with that. I don't like those kind of games, and if I can figure out something like that this quickly, there are a lot of people out there who are going to work harder than I did to try and get to an answer. So I'm concerned about that.
So I agree. I think that's the problem, but then I also think you can't say just straight up 18%, because we know that nets in really unrealistic child support numbers that are far too high for people to pay, which is why we have the brackets that drop us back down. So obviously I think we're starting at too high of a percentage. But then Wisconsin has about the same percentage that we have, but what are they doing different, I guess is my question, that they're having better results than we're having.
Keith Pickard for the record. I think that they deduct the personal reserve first, so that's going to reduce the income that's then eligible for child support. But again, I don't have anything in front of me that suggests what that should be for the average person in Nevada. I wonder how we go about figuring that out. But my understanding of Wisconsin was that they deduct that right out of the gates, and then they calculate based on the straight percentage after that. That's my recollection anyway.
Karen Cliff from the Clark County District Attorney's Office, if I could just provide some information. So prior to today's meeting, I did make sure that all of you have some various Wisconsin statutes. I provided that just so we would have some information when we speak about the self-support reserve, low income adjustment. But in doing so, just to kind of provide some information regarding Wisconsin, although, of course, I'm probably not the best source on that, I do have their statutes in front of me. So I'm referencing specifically DCF 150.03. And Ms. Surratt is completely accurate. Their formula is very similar to ours. They do take from gross monthly income. One child is 17%. 2 children, 25, 3 children, 29, so on and so forth. It's exactly like Nevada. With respect to the self-support reserve, low income, that is a deviation factor. So one of the statutes I provided for today, which all of you should have a copy of, and again, I'm fast forwarding because we're not quite there, but it is, I think I even asterisked it, and I might have even put self-sup, but it's 767.511, 767.511. That was part of the attachment. Subsection 1M, deviation from standard factors, and I put a little asterisk, and it's BP, the needs of each party in order to support himself or herself at a level equal to or greater. So just in providing some clarification with respect to that, it appears from what I can see, Wisconsin does take that gross income. They use that same type of statutory formula we utilize, but their deviation factors are noted in 1M. Thank you.
Joseph, would you like to speak next?
I did. I think the initial question is going to be when we're looking at whether 18% is fair or unfair. It sounds like I think the discussion is that it's unfair at the higher levels, and I'm not going to disagree with that, but are we talking about changing the 18% for everyone, or do we want to just start at that upper level? And if we are going to start at the upper level, what income do we want to start thinking about changing the percentage? That makes sense. If we're talking about changing it for families making, say, $10,000 a month or more, and then shifting the bracket from 18% to, say, 12% or whatever, I think that makes sense. But if our concern is that the 18% is too much at the high levels, then do we want to change it for all families, where at least the data provided in the report showed that the 18% was sort of within the norm?
So to give an example, when I took our presumptive maximum amounts and I looked at the different brackets, so if you made between $0 and $4,235, obviously you're at more than 100% of your, if you're at $0 and you're at our minimums, that's why we're going to fix our minimums, then you've got a different problem. But if you make $4,235 a month on that first bracket and you pay the presumptive maximum child support, you're paying 16% of your income. So automatically, just based on our brackets, we're dropping from the 18 to the 16, which tells me 16 was really where we were supposed to be at versus 18. I mean, that was the goal there, presumptively. The next bracket of income, if you're at 4,235 to 6,351, you're paying anywhere, you're starting at 18% of your income. By the time you get to the end of that bracket, you're paying 12% of your income. The next bracket, you start at 13% of your income and you go to 10% of your income. The very next bracket, start at 10% and you go to 9%. Then we have 9 to 7, 8 to 7, and then 8 and anywhere below that, because we don't have a cap. It's endless after that about your income, what percentage it's going to be. So just taking that first bracket and looking at, because if we don't do anything to modify, if all we say is we're going to get rid of the brackets, we have to do more than that. We can't just get rid of the brackets, because we already said it wasn't a reasonable amount using these charts before, that we needed to drop the child support from there.
If I could just
Yeah.
add just one more thing on the Wisconsin, because we have referred to it a couple of times. They do have a special statute. It's DCF 150.04. It's titled, and this one is not before you today. It was not one of the statutes I provided, but it's determining the child support obligation in special circumstances. That has a subsection 5, determining the child support obligation of a high income payer. So they have a separate provision in their statutory scheme for high income payers. Their determination is where the gross monthly income is $7,000 or greater. That's where the statutory scheme changes. So it's 14% for one child, 20% for two children, 23% for three children, and it goes up 2% per child. So if that assists as a possibility of maybe not necessarily changing our statutory scheme, but maybe perhaps just adding a different statutory scheme for a high income payer, that would be an option as well.
I'd also note that the report says that most states create a high income floor for the court to have discretion above that, and ours really kind of reads the opposite of that, where it's a ceiling versus a floor for that high income. But I'm back to, if we're just going to take straight up gross and apply 18%, when automatically under our old statutes we were dropping it down to 16% or somewhere below that, depending on your income level, then we're not at a starting percentage that makes sense. And perhaps again, it's looking at child rearing costs and the economic factors that they talked about in this report. I don't know if you have to backdoor it. It's what is the reasonable child rearing costs. What you look at those economic numbers and you back out your numbers to the right percentage or not. But I would agree. I kind of like the Wisconsin way of doing it for high income, or the concept of what the auditor said, which was you create a floor, not a ceiling, for max income.
If I can jump in, Judge Hoskin again. I think we're circling around the economic cost or economic data of raising children, and I don't know, I think Ms. Pickard indicated that earlier, that we're kind of not there yet. Of course, I think we talked about it in a previous meeting, I don't remember how many meetings ago, that number is going to be different for a low income than it is for a high income because of expectations and other factors that may come into play. But maybe if we can define, are we going to start looking at what's the number for the low income? What would that need be, and formulate that and compare it to what would perceivably be reasonable in a more high income situation, just to kind of get us narrowed and maybe try and find out where we are with the formulas. I think from everything that we looked at, although there's some problems with our 18, 25, 29 scheme, it seemed to kind of fall in line with where we probably need to be. But I would feel more comfortable in this process if we know what those numbers are for cost of child rearing. I mean, I can tell you for me, but I can't tell you for the rest of the state.
This is Keith Pickard for the record. I just want to note for the record that he said I was correct. That's a first. He just said it won't happen again either.
Yeah, it's a good thing it's not the legislature. Nova, I'm going to put you on the spot. I'm sorry. What? I want to ask you a question on the record. So Keith just mentioned about child rearing costs and getting that economic data. And I know our auditor talked about that data a lot, but do we know, she's looking all over the place, do we know where we can get the data specific to Nevada? That's why we have child support experts on the panel.
This is Nova Murray for the record. We intentionally put an economist on our panel here, and she's with us, so I'll defer to her response.
Well, I pulled the USDA data. We could look at the USDA amount and try to adjust it based on the cost of living in Nevada, just using some basic economic data like that. I haven't done that, but it would be relatively simple to do. But I don't know that you're going to see the how much it costs to rear a child for low income versus high income, but I can look into that and see if it's possible to, convert the national analysis into something that's more applicable to Nevada.
This is Bridget Robb.
I like that.
This is Bridget Robb for the record. I like that approach as well. I'm just wondering, we've focused our attention so far today on high income, and quite frankly, that is not the bulk of the clientele that I see. I'm seeing litigants on the low end. And if we're going to spend our energy, that's where I think we ought to spend it first, is let's talk about what is reflected in, for example, the Wisconsin model, which is DCF 150.04, which is, and determining the child support obligation of a low-income payer. I think that really it should be our most obvious starting point. And once we get that nailed down, then we can talk about the higher payors, because they really are, at least in my experience, the exception, not the rule. And I'd rather work on the rule first and then get to the exceptions.
I'd agree. And looking at the Wisconsin, they have that chart that was given to us last time. Yeah, well, I think it was last time. So, and I think Assemblyman Pickard's comment is probably the most relevant, that what they do is they take out that self-reserve first before they do the math calculations, which is what gets you on those low income numbers to a reasonable amount. Because you'll see on monthly income up to $754 for one child, it's only at 11.22%. And then it goes up to 17% at the $1,500 mark of income for one child, which gets you to those reasonable numbers. So unless there's objection, I think that we should skip around on our agenda and skip to,
Madam Chair, before we
Yes.
leave that. I had it backwards. As Ms. Cliff pointed out, it's a deviation factor. So we start, or Wisconsin starts with the calculation, and then when someone's alleging the low pay and the need for consideration of the what I keep calling the personal reserve, that's when that is considered. But ultimately, as Judge Robb was saying, I like the idea of making adjustments because obviously our numbers and Wisconsin's numbers are going to be very different in terms of what it costs. And I agree that it's more likely to be considered at this end of the spectrum than the high end. But at the end of the day, I think that we can kind of kill both birds with the same stone. In doing the economic analysis, I think we should be looking at the self-support reserve, based on federal poverty level and the cost of living here in Nevada, and then at the same time determining whether or not the adjustments to the child, the typical child expenses. I think we can do that all at the same time if we can impose upon the DFS economists to do that calculation. I think those would be two data points that would be very helpful in starting this calculation discussion.
additional comments? Okay, what I was going to discuss was, with that information, moving on to item number 4B, just for the purposes of going through it a little bit right now and supplementing this discussion, because 4B is discussion and recommendations as to how to set a minimum order with a self-support reserve / low-income adjustment pursuant to item number 7 of Exhibit 44 and the action items from the September 26, 2017 meeting. And whether or not, I mean, obviously that's going to affect what calculation we put under agenda item number 4A. But my discussion points for 4B would be that one of the comments on page 11 by the economist in this review report was that minimum order, we of course in Nevada have $100 per month per child. Other states have a $50 per month per order as the typical guideline. For low-income adjustment or self-support, we have none, and she puts in her chart, most states set the guidelines amount for obligated parents with poverty and or near poverty income below what it costs to raise a child. And she put the next bullet point, the most common low-income adjustment is a self-support reserve that relates to the federal poverty guidelines level for one person. I like the combination of the two. I know last time during our meeting we had discussions about not getting rid of having absolutely no minimum, at least having something in there. There's a dramatic difference in setting your minimum at per child versus per order. Automatically you're getting to much more fair numbers. Personally, I like the $50 per month per order as a minimum, and setting a low-income adjustment as a self-support reserve that relates directly to the federal poverty guidelines level for one person. Input, thoughts?
I have a question,
Madam-
if I may.
Go ahead.
Thank you, Keith Pickard, for the record. When we first started talking about the federal rules and the 4D program, one of the complaints was the number of deviations that we see. And so when we talk, and as I was corrected today about how Wisconsin does it, they're creating a deviation. And so I'm wondering if that then dings us in terms of the statistics or if that really is the way to go. Otherwise, we can build it into the process, and we avoid that deviation. But I'm just wondering, is that deviation in Wisconsin problematic under the 4D program?
It would be considered a deviation. I mean, that is one of the things under our report that really hit us on the list of deviation factors, and the fact that every single time, just on for health insurance as an example, every single order nearly that has health insurance in it is a deviation, which means the feds are counting it as a deviation. So I don't see any problem with us doing the opposite of Wisconsin, which is it's part of that upfront calculation. It's set in stone how the court's to do it versus being a deviation factor, which means taking the discretion away from the ability to mess around with that. We want them to have to calculate it a specific way. I'm in favor of that. I don't see why we couldn't accomplish that and still have the same outcomes as Wisconsin.
Thank you.
My preference, and of course I'm just speaking on behalf of Clark County 4D program, would be to make it a deviation factor. My position would be to have a statute that states that where income is unknown, it is presumed that the child support amount that's calculated is equal to the minimum basic needs to adequately support a child, and absent testimony, findings, and specific direction from the court that the respondent or non-custodial parent does in fact have an inability to support the child based upon the statutory formula that was used, we could then deviate. That is because, again, as I've stated in previous hearings, we don't always have parties that are active in their child support case. So to automatically, on every case, have to try to guess whether or not the respondent needs a self-support reserve is very complicated. My position is those are findings that need to be made on the record. The judge needs to weigh that. We have to really consider, what is his rent? Is his rent too high? Is her rent too high? Is that car necessary? So we need to take testimony on all of those things to determine if in fact they meet the criteria. So my position would be that it is a deviation factor, and it would not run afoul of any federal guidelines.
This is Nova Murray, for the record. What if we made it a non-deviation factor with the ability that a judge could always deviate going the other direction when we do know their income and we do know what's there, and in an unknown situation the judge deviates?
Because as you know, Ms. Murray, oftentimes our parties are not participating, and Nevada does create orders through default.
Okay, but if you're creating an order based on default, okay, so you have parties that walk in, you don't know their income level, you determine what you're going to impute as income. If that what you're imputing is under the poverty level, then the calculation says that you have to apply the self-support reserve. I don't see that as a deviation, and I don't see why it needs to be a deviation because it's based on you need to determine an income level. And if that income level is below the self-support reserve, your calculation has to take that into consideration.
How do we know that it is below?
Well, I understand that you may not know.
Welfare.
Right. So, but how do you know what it is? Whatever you're assessing, you have to come up with what the income is that you're going to calculate off of, whether it's a low amount or a high amount. You don't know either number when they're not in front of you.
That's correct.
Correct.
But I guess maybe I didn't understand what you were saying. It sounded like you were building in a self-support reserve.
Okay.
Is that what I'm
No,
hearing?
so in all circumstances, no matter what, even with the self-support reserve in place, you have to determine what income level you're working off of for that party in front of you. Whether you're imputing it or not, because they appeared and you have the data or not, you're going to determine an income amount. Whatever that income amount is, then you look at it and say, either it's low enough that you, in the calculation, need to consider that self-support reserve or not. I mean, you're saying to me you don't know whether or not they're so low that they should be, that poverty is a concern, but you're going to impute something. You're going to impute either a really low number or a number that's more based on economic data about the job that you know they have or you think they have. You're putting some number in place. So if you know they're working a very low-end job and you know they're at that poverty level, why wouldn't you just automatically apply? I don't understand why it has to be a deviation. It's part of the calculation. You don't know the income one way or the other.
We do the best we can to assess income. My feeling is, and unless this is coming to a vote, again, this is just my position on behalf of Clark County 4D program, is that the adjustment is made just like the Wisconsin statute as a deviation factor. My feeling is the court shall state the reasons to support the adjustment. And when you have something like that that's clear, it's easy for us to bring it back. Just even on a modification to say, okay, this was the income based upon this rent or this car payment, this medical insurance, etc. This individual falls below, does now qualify for low income. Support is now set at this percentage, and if the individual somehow is able to pay more child support, we bring it back in on a modification, and now maybe they're set at this percentage. I have no issues with the way Wisconsin has drafted their statute. If the proposal is that we do it differently, that's fine. I'm prepared to vote on it. But my position is I do like the way Wisconsin has written their statute, and I like it as a deviation factor.
I think we're on two different pages still. I guess the point is, no matter how Wisconsin drafted it, sometimes it's a matter of linguistics and what we call it. And when we take that into consideration as to whether or not it's part of the formula or it's an actual deviation factor, we are under a dictate from the feds to decrease on deviations. So, at the end of the case, at the end of the calculations, if the judge still has reasons to deviate based on this family and these circumstances, that's a deviation. But they want to see a greater number of solid math calculations on the front end from us. So when you come in and you say they're at low income, no matter what, they're at a income level, whatever it is. If it happens to be a poverty level income, are we going to ignore it because we haven't done the deviation yet because they didn't show up? I don't understand that concept, because the low income part of this and the self-reserve part of this is just pure and simple. You're either at this income level or you're at this income level, lower or higher. Where are you at? And if you're at higher, then you don't qualify for it.
I get it. Just being in the 4D program, we often have individuals that are not necessarily forthcoming about their income.
Right.
Just to sort of give you an example, we have individuals that maybe are not interested in working to the best of their abilities. We do partner with a job placement program. We do ask our parties to please try to get job assistance. But my feeling is it should be a deviation factor, and that deviation is presuming the income is legit, presuming they really are struggling in a way that they're at the poverty line. Of course, they would be eligible for it. But you oftentimes in our program will have individuals that are being supported by their family, supported by a significant other. Income is difficult to determine. On paper, it appears that they would qualify for this low-income guideline, but in reality, a large percentage of our population does need some additional motivation, some job placement, and some encouragement.
So you're imputing income in those cases?
No, we don't impute income. The statutory minimum is used frequently with, again, referrals to a job placement program, a return date. But I am not quite comfortable with doing it any other way than a deviation factor. But of course, there's many members on this board, and if that's the direction it goes, I accept that.
This is...
Just Judge Hahn, go ahead.
Go ahead. Judge, if you want to.
My thought is listening to the two positions being debated. I don't know if debated is the right word. This is only going to come into play on the lower end. And certainly, I think we can probably come up with a formula on the low end, depending on what the scheme ends up being, that would take into consideration the self-support portion of it and still allow for the 4D program to function and be able to still put orders in place that they're able to enforce. So I guess what I'm saying is I don't know that the debate is so much about deviation or non-deviation as it's a very limited category that we're dealing with. Will fall into that self-support area, and certainly we can draft formulas around that to deal with it if we're trying to eliminate a deviation rather than just calling it a deviation and still come up with something that's going to be easily enforceable by 4D. So I think that there's a mechanism to resolve the discussion we've had lately without the definitions of this or the syntax that we're putting on it.
This is Bridget Robb for the record, and Judge Hoskin, you actually preempted part of what I was going to say, which is I think we're having a semantic argument right now, and my recollection from some of the testimony we heard last time was there was a question about what was clearly to me under our formula a deviating factor. And the witness, and I apologize, I can't remember which speaker it was, but the witness said, oh no, that's not a deviation factor, that's a different kind of factor. But the word he used meant exactly deviating factor to me. So if what we're trying to do is sidestep the use of deviating factors for purposes of the federal guidelines, I think we can get there. We can serve the 4D needs by calling this something else and giving us a little room there. The next comment I have is I'm looking at the schedule that is behind. It's the Appendix C to the Wisconsin model. And my question is, do we know how this particular schedule was accomplished, where these numbers came from? They're adjusted, it appears yearly, based on the federal poverty guidelines, which I like very much. And as I look through, rather than a flat $100 per child, if you look, it really scales up so that the number of children that you have, you're actually at some point, instead of that flat number, you're meeting the needs of both the needs of the children, but you're also meeting the needs of the people who are paying this child support. It's a very, very discrete schedule in that the steps are very small. And I'm just wondering how it was created, because this intrigues me a great deal for that self-support reserve. And if we have these kind of just set using the federal poverty guidelines, I think we've met some of the issues that the 4D programs would have, because we've got the percentages set right there.
So, Ms. Robb, I provided that Appendix C for the committee's review today. It is from Wisconsin. It is adjusted yearly. The copy before you is the most recent guidelines, and this is provided in the same child support manual along with the deviation. And when you go back to the 1M, the deviation from the standard, they quote the 42 USC 9902, but they do refer to this chart, and it does appear to be very helpful. I like it.
I like it. My question is, how did they come by it? Who developed this? Because if we can use the same or a similar process using numbers that are better suited to Nevada, if we need to, since this may be useful in Nevada because it's the federal poverty guidelines. I'm not sure. But I'd be interested in knowing how this was created. I know where it came from, and I know that you supplied it. I'm just interested in where they got these numbers.
I don't know how it was created. Maybe Ms. Murray could ask someone from Wisconsin to provide that for us. I can say that I looked at Washington as well, and they do something a little bit similar. They take 125% of the federal poverty guidelines. I think on the low end, their monthly income is $1,256. I'm not sure if that's because of the percentage change, but yeah, and so in looking at Wisconsin, you're looking at a monthly income of $754. So
The
I don't know, I'm
754 is 75% of the federal poverty guideline.
yeah, so I'm presuming that each state can choose which percentage of the federal poverty guideline they wish to go with. That would be another conversation for us to have.
I've got a question, Ozzie Fuma down in Las Vegas, and forgive me for the simplicity of it because I'm probably the only one in this room that doesn't practice in family court, but why is it that we need a determination or run by a formula or follow a federal guideline? Why can't the judges make an individual determination on a case-by-case basis every time there's an issue with it?
This is Judge Robb from Reno, and you just hit one of my hot buttons in this particular area, which is I can't give you the exact number of district judges that we have right now, but if we did it that way, every single child would be treated differently depending on which judicial officer they were in front of. And I am greatly concerned that with some of the proposals that were made before previous legislatures, there was the desire to give that kind of judicial discretion. It would absolutely destroy 4D because they wouldn't be able to process the numbers that they need to do in the child support enforcement. That's one reason. But number two...
With all due respect, Judge, but that's what you signed up for when you became a judge. I mean, each child is different, are they not?
No.
Whether a child who lives in Searchlight, Nevada is different than a child that lives in Clark County, is it different than the child that lives in Jackpot, Nevada? And each judge in that particular jurisdiction would probably be better suited to determine what the needs are for that child in their jurisdiction.
I couldn't disagree with you more strongly, sir. I could not. And it is because children who are situated in Clark County, in Elko, in Tonopah, in Washoe County, all should get a certain base level of child support. And we aren't guaranteeing that if what we do is simply dump all of this into the laps of various jurists.
May I jump in real quick? Assemblyman Fumo?
I have one follow-up. Yeah.
If I may, we can have this discussion, but the federal dollars that we're here for, that we're trying to maintain and continue to come into the state for enforcement purposes, and the dictate from the federal government is that we must have specific guidelines. We can't not have guidelines. By federal mandate, we must have guidelines, and they have to be specific. They have to have the least amount of deviations possible. They want us to have it more specific. Part of that is a drive from the public saying, we want to know what we're up against. We don't want the discretion of a judge who can order just anything out of the air. People want to know that two people situated similarly, living right next door to each other, go into the court, have about the same income levels, are going to come out with about the same child support amount. That will not happen if you got rid of the calculations. But we can't get rid of the calculations. We have absolutely no right to, under the federal funding for enforcement, which is every bit of the dollars that is paying for our deputy DAs that are on this commission, the masters who are doing the enforcement, all of that for collecting child support comes from the feds. We don't have a choice.
So it's about federal dollars. That's what I wanted to hear. Okay, you answered my question.
All right. Okay, where are we? I want to jump in on that chart because I think this chart answers a little bit of what where I was going with the self-reserve amount, which is if it's already contemplated, it looks like it is when you look at this chart, when you're at that low income level, it's already contemplating the fact that you are at poverty level, and we're going to set it at only 11.22%. There was some math calculation taken into consideration in this chart based on the fact that you started at a low income amount and it was already there. It's calculated in. One of the comments that Judge Rob just made to me was, well, why start at 75% versus using a baseline of 100% for federal poverty guidelines? And I think I'm along those lines too. I mean, you're not at 75% of poverty. You're at 100% of poverty level. So why not start there as a starting basis, Mr. Sanford?
Just regarding this chart and the comment you just made about the 100%, I think the concern could be, or at least would be for me, is that essentially we come back into the bracket problem that we have at the high end, which is that if you're $753 a month, your child support amount is zero, but if you're at $754 a month, your child support is $85. And that would be, I think, problematic, or at least that was my recollection of the person from Wisconsin's testimony, was that if they were under the 75%, there was sort of an assumption that the state aid for both parties was going to be covering that piece, and that since both parties were likely to be on state aid, there was no purpose in charging a child support amount. But my concern with moving it to say something like just starting at 100% is that you're encapsulating a large number more people who are going to be in this zero category with a sort of a desire not to make, exactly 100% of the poverty level.
I don't read it that way because it's monthly income up to, and the up to is 754, which my understanding is that 754 is 75% of the federal poverty level. So I don't understand if the federal poverty level is $950 something right now. I think it was it's 1,005. Okay, so why would it not be monthly income up to 1,005 and you start your chart at that 1,005 at the poverty level?
So there is no zero.
There's no zero. That's their minimum based on this chart for monthly income up to that amount for one child is $85 based on this chart.
That could be the case. I was trying to recall from last meeting's testimony. That was maybe that was a different state.
Okay.
But one of the states at least was in that boat, and I thought it was Wisconsin's.
And of course, we're looking at a chart that only goes up to an income level of 1,508. And as Assemblyman Pickard testified about what they do with those higher levels with the percentage and how they keep going up from there based on those higher levels. Which,
if I can
again,
jump
I'm more
in.
worried about what we do with this low-income part because that's the discussion we're on. Go ahead.
Yeah, and at least the way that I understand this chart is it stops at 1,500 because that's when you get to your 17, 25, 29%. So from there, it's just percentages. So this covers below the percentages, below in that 75 to 150% of the poverty. My understanding is that's where this chart is, and I agree with you that there's not a zero order the way that I read this. The low end is $85.
Although I will say, based on the documents we got, DCF 150.04 from Wisconsin says, and actually it's DCF 150.03, but if the payer's monthly income available for child support is below the lowest income level in Appendix C, so that's the chart we're talking about, the court may set an order at an amount appropriate for the payer's total economic circumstances. This amount may be lower than the lowest support amount in Appendix C. So that's how they dealt with that. And then it goes on to say they'll revise the chart each year. I'm still liking this model. Have we had much testimony that anybody doesn't like this model a lot from Wisconsin, to be specific about what I'm talking about? I mean, that's the one thing I haven't heard out of this group is that they dislike it.
I suspect that we all tend to like this because this is what our original set was based on, so it feels comfortable. as to Appendix C, remember that this is the low-income payers at 75 to 150% of the 2017 federal poverty guidelines. So 754 is 75%, and the 1508 is 150%. So this is just looking at this small window, and I like the idea because above 150%, we just put them back into the ordinary calculation. Below that, we have essentially built in a minimum order of $85 per child. If we adopt this, then the Wisconsin deviation for a minimum of 50 tends to make sense, because what that would be a consideration of someone who is making less than $754 per month. And for whatever reason, we think that it needs to be less than 11.22% of their income or less than 85, so it allows the court to deviate down to a minimum of $50 if we end up setting it there. But above this, we're back into the ordinary calculation. That doesn't then answer the question if the 17% or more is still appropriate as we go up the scale. That's a separate question. But as to the low income, I think this adequately accounts for the low income payer. Now, the piece that I don't know is the self-support reserve baked into these numbers? If it is, then we can account for that. If it's not, I don't know how they interplay, and I'd like to know more about that.
I think there's self-support reserves built into this. I mean, it automatically has one, essentially. I mean, it has it dropping down to the $85. Even though the percentage for one child is 17%, it's got it dropped down all the way to 11.22% for that $754 monthly income up to $754.
Intuitively, I agree with that.
Yeah.
I just wonder if that's actually the case, and I'm wondering if we can find out.
And just wrapping back around to the discussion we were having earlier, if we follow Wisconsin, which people seem to like, then we have, if it is or not baked into this, we have this, and there's also an ability for the court to deviate at least down to whatever our statutory minimum ends up being, so that we've covered both bases if we stick with something similar to this. So maybe this solves the problem.
Do I be as brazen as say, do we have any motions? Not yet. Do we need time to think about this some more? I hate that concept because we're here. We've got time to talk about it and work on it. So I'd rather continue holding everybody's feet to the fire for it. Yes, Ms. Murray?
Nova Murray for the record. I will contact them or have somebody close to them contact them and find out the premise. Child support is supposed to be based on the cost of rearing children. So I'm assuming they used some model that gave them that information. When we receive that, I can send that information off to our economist and have her look at the methodology, because I won't understand it. I don't have a background in economy by any means, and see if she can explain that process for us at the next meeting. Thank you.
What I would love to see is, because she's also going to look up the child rearing data for Nevada, or at least try to adjust it based on Nevada, the U.S. data, and if we can use their methodology and Nevada's numbers to come up with a hypothetical, I'm trying to find the right word here, hypothetical chart that's similar to theirs, just to see how it works with Nevada numbers, that would be a wonderful thing for us to look at, to know if we're on the right track or not, if it's looking the way we're hoping it's going to look when the calculation and the math is done.
I'm happy to try to put that together. I'll see if I can come up with it before the next meeting.
We love having you on the commission, because the rest of us are going, I don't know how to do that. I wouldn't know how to start there if my life depended on it.
Nova Murray for the record, that's an assurance we have to make to the feds that we've taken the cost of rearing children and all of those pieces in consideration while we were setting these guidelines. So we can't arbitrarily say it's 17 or 16 and pick somebody else's model. We have to know how that fits into our economy and how that helps the children. And-
Judge Hoskin again, I'm sorry. I can't see who's talking, so I'm sorry for stepping on you. In an effort to move this forward so that we don't waste the last hour and a half, and my feeling from the group is that we like this way of approaching the problem that we're dealing with, and we're hesitant to finalize it merely because we're missing a few pieces that we'd like to have. Is it possible to, and I'm not ready to make a motion because I've got more of a question, that what we can and can't do, that this is the direction we're going and we're trying to fine tune so that we're narrowing rather than leaving it open? Is that a possibility?
Yes, I think it would be appropriate to have and I don't know that it's a motion so much as, because it may fall into a different agenda item for figuring out our next agenda, but perhaps, well, it might be an appropriate motion. A motion that we use this as this methodology, this as a starting point for drafting where we're going with Nevada, and then perhaps somebody on the commission is willing to start taking some of that Wisconsin language, the bits and pieces that we're looking at, and start mocking something up about the parts that we like and that we're working off of. Is that
Was that a
similar to
motion,
what you're
Madam Chair?
saying? Sure.
Yeah, is that, then I will second that motion.
Okay, any discussion? All in favor, say aye.
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 If opposed,
Aye.
say nay. All right, we're moving forward. So that was a motion for agenda item number 4B. And do we,
Madam Chair,
I'm
if
going
I
to
can
throw out, do
follow
we
up
have a
on that?
volunteer? Yes. Oh, you're
But before we
volunteering,
go to
Assemblyman
that-
Pickard?
No, no, I am not.
Come on.
Before we go to that point, I just want to make sure I understand then what the next step is. As I understand it then, we're going to have the economic response that we're going to, and we need to determine if we're going to bake in or if it's baked into the numbers or not. But we're going to get all those answers. We're going to look at the table. We're going to figure out what the appropriate numbers are for Nevada based on the, not FDA, but Department of Agriculture, I think it is, their
USDA.
numbers. USDA, that's it. And then we'll determine whether or not we have to, whether or not the self-support is baked into this, right? So we're going to find out what appropriate numbers are for Nevada, and then that will inform the calculation we've got moving forward. But those are answers that are coming before the next meeting. Is that right?
Correct. Well, the data will come within the next meeting. We'll fine tune that for an agenda item. But in the interim, we have an agreement by our economists to do the research for us, to create the chart for us, and provide that to us so that within our next meeting, we can assess that under our action that we just took, which is to use Wisconsin as a model, to move forward with it as conceptually where we're going with it based on Nevada numbers. But she's going to get those numbers for us so that we can see how it plays out and then decide what we're going to do with the self-reserve, if we're going to have a self-support reserve or not, how our minimum is going to be based on those numbers, that calculation, and use of the Wisconsin data.
Right, and if that's baked into this table, we would just need to know that, or the table that we're going to get.
Yeah, based on when we start stealing's a bad word, huh? When we start borrowing specific provisions from the Wisconsin stuff, what I think we need to do, personally, and this is where I was looking for a volunteer, is to take, because there's a lot of words and there's a lot of data within the Wisconsin material that we have. It's not just the clean parts that we're wanting to work with right now. I think we need to see that encapsulated and out in its own document so that we can start working off of that language and see what we are taking and not taking from the Wisconsin information. Because obviously the history and everything else is listed out in the statute, the Wisconsin statutes.
Madam Chair, I'm willing to take a run at it.
All right, we have another volunteer. I love it. Yay. Great. And I think that'll make a big difference for all of us because we keep referencing the different Wisconsin stuff, but it's watered down with a bunch more data and information. So when we get to our item on the agenda for dealing with the next meeting, we'll make sure that's incorporated into the agenda for the next meeting. Okay. So with that information, we have agenda item, I'm going to close agenda item 4B, and we're going to move on to agenda item number 4C, which is discussion and recommendations as to how to address the treatment of incarcerated parents or parent recently released from prison. And it is pursuant to action item number 8 on Exhibit 44. And action number 8, or recommendation, I'm sorry, not action, but recommendation number 8 in the report is that we need to explicitly address the treatment of incarcerated parents or parents recently released from prison. The how is to review and codify current practices and other states' provisions and adapt, if appropriate, for Nevada. The federal rule, final rule that came out told us that we must specifically have a provision that we are to not impute income to incarcerated individuals for support amounts. So we have a very specific mandate from the feds on this specific issue. I want to just throw out there for initial discussion that based on the last meeting, when I went and took a look at California because I knew California actually had some very decent language on incarceration, and that was very specific about the number of days of incarceration. So they have language that if you have been for a period exceeding 90 consecutive days, in which the person ordered to pay support is incarcerated or involuntarily institutionalized, your child support is suspended unless, and they have exceptions to it, which the federal final ruling did not give us any specific language about exceptions, but I think exceptions are important to be considering for this. I think the 90-day part of it is something reasonable to be looking at, that it's not just 1 day of incarceration, because by the time you get child support canceled, suspended, and reinstituted, you can't do it for incarceration for a small amount of time. You have to have at least a window. And I think it still complies with the final ruling is about imputation of income. But California says your child support will be suspended unless the person owing support has the means to pay support while incarcerated or involuntarily institutionalized. The person owing support was incarcerated or involuntarily institutionalized for an offense constituting domestic violence. I don't think the feds contemplate that, but they do have language that says the child support obligation shall resume on the first day of the first full month after release of the person. And then they also have a very clean definition about what is incarceration, which I think we need to not ignore when adopting a rule. I mean, we can just do pure and simple what the feds have told us, which is you cannot impute income to somebody incarcerated. I don't think that goes far enough for what we need. I think we need far more details than that. And I think defining incarceration, defining what it means to be, they have suspend of your sentencing defined. There's a lot more detail in here, but I just wanted to throw out there, I think if we only did what the feds are requiring of us, it's not sufficient for what we need in Nevada. Thoughts?
Madam Chair, is there maybe you said it and I missed it, is there an indication of what they're doing with the child support? Are they suspending it?
They're suspending
completely?
it. Yes. And that
Okay,
it's automatic. by
Okay, how
operation
do you
of law.
wrap-
They have every money, judgment, or order for support of a child shall be suspended by operation of law for any period exceeding 90 consecutive days in which the person ordered to pay support is incarcerated or involuntarily institutionalized, unless either of the following conditions exist. And then they go into what the exceptions are. Now, what we have from the feds was specific to you cannot impute income to somebody that's incarcerated. I do think those are two different issues. But I think if all we did
Yeah.
was put in a statute that says you can't impute income, you're missing a whole bunch of cases that are going to be up in the air about, well, you can't impute income, so what does that mean? What are we doing?
Well, and I understand that. I guess my concern is that in the rest of what we're doing, we're putting a value on supportive children and that you need to maintain supportive children and talking about everything else that we're talking about. And this seems to kind of fly in the face of that analysis and can be kind of a different approach that because you're incarcerated, you don't need to pay your support. Your children don't need that support. I mean, it's just, I'm having a hard time from a logical standpoint wrapping my head around that.
Well, except that one of their exceptions is you have the means to support while incarcerated or involuntarily institutionalized. So I guess the goal is how do you get to the fact that you can't impute income to somebody who's incarcerated because they're not, well, they may own a business that's continuing to incur income while they're incarcerated. But let's be realistic, that's not who we're dealing with here. I mean, that's not the bulk of what these matters are. So I don't know, I just want to look at, I didn't want to look at just, what are we going to do? Put one phrase in real quick that says you can't impute income like the feds want us to do and call it quits? Or are we fully analyzing this issue?
Keith Pickard for the record. Personally, I think that if someone is incarcerated, it's because of some volitional act. And mind you, I'm very sensitive to reentry issues and sponsored legislation regarding that. But I think that we should put the burden on that individual to show that, in other words, we should create a deviation factor, much like we already have, that a person must demonstrate that they are unable, for whatever reason, to get any income, and then that becomes a deviation factor. I think that to be consistent throughout the statutory scheme, one of the expectations is parents are paying support. At some level or another, they're paying support and they're obligated to pay support. And if they put themselves in a position where they can't, it's up to them to figure out how to do it. But then they would have the burden to come in and prove that they are unable to do so. And for that period of time, it would be suspended. But I believe that should be a deviation factor, and I disagree with the feds on this point.
If I could just provide some information, at least Karen Cliff, Clark County District Attorney's Office. We have an interface with the Nevada Department of Corrections, so we modify incarcerated parents' child support obligations on a continual basis. While we don't have any statutory guidelines in terms of making it automatic as California does, I think they actually put it in their child support orders that if at any given time the respondent or non-custodial parent is incarcerated, it works similar to the way our state operates with respondents on TANF. Child support is held at bay during that period of time, and when you go back to later calculate arrears, you would of course set that period of time at 0. In terms of how Clark County does it is we modify all incarcerated parents' orders if eligible to 0, and then we have language that 30 days after their release, child support is at the statutory minimum.
The only problem I have with that language is that particular type of language reinstituting a child support order has been overturned by the Supreme Court, by the Nevada Supreme Court. It said you can't do that, at least with an order that came out of the Second Judicial District. So if we're going to, and I like the idea of reinstituting the obligation, but I think we need to do it by statute rather than relying on what's in an order. Because if one of your incarcerated persons or someone who had been incarcerated takes that up, I think you lose.
So I'm not advocating right now how we address this, whether it's by order. I'm simply just providing information in terms of how Clark County does it. I think Your Honor is referring to Northrop. I believe the state has weighed in on this. In terms of how we're operating, we are well within the state guidelines. Those from the state are free to weigh in, but at this point, that's how Clark County is operating. And I'm not saying moving forward that's my position. Just providing information in terms of upon release. Those are the types of orders we're making.
I guess my point is this. If that's what we want to do, let's bulletproof it by putting it in the statute as opposed to just relying on language in an order. If that's what we
Absolutely.
want, let's do it by making the recommendation here.
Agreed.
All right, come on. This is a hot topic. You can't tell me nobody else has any more comments.
All right, fine.
That's what I thought. I mean, come on. I know what and I agree, Assemblyman Pickard. It's frustrating when the feds are so point blank on something, but they are on this one, on the imputed income part of it. But I think there's room for us to work around that. So go ahead, Judge.
All right, and I don't disagree with your concern with regard to including in what we're doing here a little more direction beyond not imputing. My only concern was I'd like to be consistent in what we finalize, that we value the support of children, which is why we're doing this, and somehow we've got to incorporate that into still comply with the federal guidelines. So if we're looking for a motion at this point, I would move that we consider what you've just presented to us with regard to going beyond what the feds have suggested and including additional language with regard to the stuff that Ms. Cliff has talked about, that Judge Robb has talked about, so that we include that as part of what it is that we're accomplishing here today, which didn't sound really succinct.
But I'll second it.
I don't think it's specific. Okay, with discussion, I don't think it's specific enough. We're just going to take all that discussion we just had and make that a motion. Would you like to restate your motion more specifically?
Well, since I don't have in front of me what you had in front of you, it's going to be more difficult for me to be that succinct. So perhaps you can assist me.
Let's piecemeal this together between Ms. Cliff, Judge Robb, and myself. We're going to have as a starting basis. We're going to take the language mandated by the final rule by the feds. We're going to incorporate additional language from California's Family Code 4007.5. And then, Ms. Cliff, do you want to try to phrase what it is that your statement was?
Well, we're open
Summarize.
to ideas. I was just sort of indicating at least what we do in Clark County in terms of actively modifying the orders based upon incarceration to 0.
And to add in, this is Bridget Robb, for the record, to add in the language where an obligation is reinstituted when someone is released from incarceration.
And so
I think the
that
California
I guess,
rule does a pretty good job on that because it defines when your incarceration is suspended too. Okay.
So I just want to be mindful with the reactivating of child support in that oftentimes prior to incarceration, the child support may be set higher because individual had a good paying job and now this individual is released and now has a criminal record and is not necessarily able to pay that exact support amount. So reactivating, what is that? Are we just reactivating an obligation? Are we creating an obligation that maybe is based upon an ability to pay, or do we reactivate and maybe look at it for a possible modification? We don't reactivate the previous amount because of the Nevada Supreme Court case that Judge Robb was referring to. We set an amount at the statutory minimum. So I'm just throwing that out there again, just as an idea to consider, the ability to pay piece of it.
So do we add that it's grounds for review and modification? That release from prison or incarceration, not necessarily prison.
Yeah, I think it's a good idea. And I like the 90-day, was that part of your California reference, that they need to be incarcerated for at least a 90-day period before we make that consideration? Madam Chair?
No, I didn't hear that was a question. Sorry, I was thinking about something else. Go ahead. I'll be honest.
I appreciate you paying attention.
Yeah, well, I was taking notes.
This is Kathleen Baker.
The question, sorry.
I'm sorry,
Just
from the-
to restate my question, because the chair is in the middle of the motion, as I understand it. You referenced some California statute. Is the 90 days, they have to be incarcerated for 90 days, is that part and parcel of your recommendation before we start considering that they're incarcerated? Or was that something separate? I know you said
No, that
it.
was within the California statute.
Okay.
I like it if the rest of the committee is inclined. I think 90 days is a good starting point. I think it's sufficient time. Unless anybody has any objection to that. Okay.
Yeah.
And now,
Dawn
the
Throne.
California statute, to be clear, though, has an exception that you still have to pay, that your child support is not suspended if the offense was constituting domestic violence. I don't know, I mean, the federal rule just says you cannot impute income for incarceration. There's no exceptions for the purpose or the reason why you were incarcerated. I'm sure that was a lobbying effort as to why that's in the California statute. But thoughts from this committee on the domestic violence language, please.
I do. Ozzie Fumo from Las Vegas. This is in my wheelhouse. I've been practicing criminal defense for the last 22 years. I don't think you can include domestic violence in there. Our statute includes situations with family members, brothers, sisters, mothers, fathers, wouldn't include the wife, and so I think it would be an injustice to include it in this one here, unless there's a specific finding made. I don't know if the judges want to make that or just want to follow a statutory guideline, but if they just want to follow the guideline, then it can't be included. If they want to make a specific finding that it was against the mother of the child, then perhaps.
I don't like the idea of carving out categories the way this has been done and assigning value judgments to types of criminal activity. I mean, I understand and am very sympathetic to the domestic violence issue, but so you've committed, as the person who is the payor parent, you've committed a violent act against someone who's not a member of your family. I don't know why that isn't as serious as an act of or would be considered less serious than an act of domestic violence. I've got some real problems with the moral judgment that's being made and the slicing things as thinly as that. I would be against adding that particular exception.
Okay, I think we have pretty good consensus there.
Yeah, I
mean,
wasn't
it's part
proposing
of-
that.
Go ahead.
Karen,
Necessarily proposing it. I was just saying it can't be included in there.
Yeah.
Karen Cliff, just real quick on the issue, Clark County District Attorney's Office. The state used to have some policies on this, and with Ms. Murray there, she could maybe add to it. But in the past, when the crime was committed against the custodial parent in the case, our office would not modify the cases to 0 based upon the nature of the crime. We did not want the individual to benefit from the crime to avoid support in doing something to the petitioner. That is no longer a qualification in our office, reducing cases to 0. State policy removed that provision. Just throwing something out there, it's not that one crime is more egregious than the other, but in terms of addressing a non-custodial parent that commits the crime against the child in the case that's at issue. Just, again, for consideration.
Something else
Keith
I want
Pickard for the record.
Go ahead.
Yeah, I just wanted to point out that under the final rule, this is section 303.8, they actually say that it's after learning that a non-custodial parent will be incarcerated for more than 180 calendar days, not the 90 days of California. Personally, I think that given the time that it takes to get in and reconsider, I think that the 180 days would be more appropriate, but that's just my feeling.
I would,
By the way, that's on page, it looks like 93497 of the final rule.
so that dovetails into the comment I was going to make, which kind of was a lesson learned out of this last session. There was the statutory change regarding if you are on TANF, then your child support obligation is suspended. But after discussions with the Washoe County District Attorney's Office, it was, well, their system has no way of knowing somebody went on TANF, and we didn't put any additional language into that legislation to talk about putting the onus on the person who's receiving the TANF to give notice to the district attorney's office that they're in fact on TANF. So I'm assuming we may have the same issue here, which is, do we want to incorporate language that the payor has an obligation to give notice, because you don't have a magic button that turns off their child support and suspends it, knowing, well, I don't know, your system may be better equipped to know they're incarcerated than it is to know if they're on TANF, but I don't know the answer to that. Do any of our deputy DAs know?
Again, I can weigh in for Clark County, at least. We are aware when they're on TANF, and we are also aware when they're incarcerated. Not in federal. We have an interface with the Nevada Department of Corrections, but we do have the ability to determine those things, not necessarily immediately because we're not actively involved in every case at any given time, but in terms of recalculating the arrears, it's simple to go back into their TANF history and look to see that they're on TANF and remove support during that period of time. Same with the incarceration. We would just remove child support during that period of time. But I don't know
you
if the
say you
other
remove it during that
jurisdictions have
time.
that.
So you could be going back and removing it for that time period. The concern became if the recipient was receiving child support, do they owe it back? Now, are they dinged for the non-notice, et cetera? So I want to make sure we have sufficient notice language that requires.
I don't know.
removal.
Well,
But you don't know
I don't know
federal.
if the petitioner would receive it because the respondent is incarcerated. So during that period of time, the petitioner is not receiving anything.
Because nothing's being garnished.
So there's-
right.
Nothing's being garnished. In those rare instances with TANF, although we're getting off subject, there are moments that the individual is working, and of course, there's payment. The statute doesn't address that particular scenario. But with an incarcerated individual, unless there's some sort of trust, generally there's no payments going to the petitioner during that period of time.
Would you prefer language that says the payor still has a duty to give you notice versus you having to
Yes.
find it out? Okay.
Absolutely, yep.
So I'd probably suggest we incorporate that into the language. Do we have objection to that? Okay.
This is Joe Sanford for the record. Again, I like the idea of notice to the district attorney's office or whoever the enforcing authority is. I just wanted to clarify whether the suspension as an operation of law is being included in this, or whether the intention is going to be, if we're planning on already having them do notice, that we would have a hearing to make this determination whether they're, because in the California thing there is exceptions. So is the intention to have a hearing, or is it to just be an operation of law? They'll come back in however many years after they're released from prison and then say, hey, I was in prison for this time and I want you to adjust my arrears.
This is Kathleen Baker from the Washoe County District Attorney's Office. I actually am in favor of having a hearing, partly because I think what we need to determine is whether they have the ability to pay. If we have an automatic suspension, they may have the ability to pay. We've just suspended their child support.
I think that might be problematic, though, if they're incarcerated, they can't then attend the hearing, but I actually agree with
easier
you.
they can. I'm going to interrupt that.
Well,
it's easier.
yeah,
We know where they are.
that's true, you know where they are, but you're assuming that CCDC is going to actually transport them, and that has been pretty problematic in the
They don't
past.
need to be transported. They appear by telephone all the time.
They do not for CCDC. CCDC will not allow them to appear by telephone, and as all of you know, they can serve time in CCDC up to a year. So we're unable to get CCDC inmates to participate in their hearings.
Nova Murray for the record. I remember where I was going with this. With a parent-child relationship, we already know their income before they got incarcerated. So they were either working, they had a business, or they had RSDI. the biggest one that's going to go with you is your RSDI, because it doesn't close when you get incarcerated. And so what we know on the day before they go in is the same thing we know the next day. And we know that if you don't go to work, you don't get paid anymore. And we know that if you go to prison, we know what keeps going with you if you own a business. So I think we can make those decisions in the operation of law because we knew them before they went in, and we kind of have judgment to know who we need to speak to afterward.
From a 4D perspective, you do, but I mean, if they owned a business that still has income coming off of it, you've got, I mean, I've always wanted a job with residual income. A lot of people have that. I mean, there's insurance brokers, et cetera, that have residual income coming in. Financial advisors commit financial crimes, et cetera. So, I mean, I don't know that that income goes away, but obviously from your run-of-the-mill case, with their job, they no longer have their job. As they're incarcerated, thus they no longer have that income. I would agree for certain cases, but not 100% of the cases.
Well, and I would say to make your deviation less, you would automatically adjust it in most cases unless whoever has it suspects there's a way to pay. So I would eliminate the deviation by making it an operation unless that happened. I can't imagine that you didn't tell us about something before you went to prison, and then all of a sudden you have new news for us now that you're a criminal.
Go ahead.
This is Kathleen Baker again. That certainly might work for cases where we have ongoing support, but I've had cases that are establishment cases, and we're establishing paternity, and we're also trying to set a child support amount for a parent that's incarcerated.
So the way the California statute is written, it's suspended by operation of law, and then it just says unless the following conditions exist. And one of the conditions is that the person owing support has the means to pay support while incarcerated. So it alludes that that's a right to a hearing, or at least it's a right to ask for the court to review and assess by the recipient. It kind of puts the obligation on the person not going to jail to have to go into the court and say, well, wait a minute, they actually have the means to pay. Mr. Sanford, I can see you about to push your button, so you get to talk.
Thank you. This is Joe Sanford for the record. I think the folks who are going to jail or prison for more than 90 days and will have some actual ability to pay is, just in my experience, at least through the 4D program, very, very limited. And so as part of the 4D program, it would actually be, I think, beneficial to us to have it as a operation of law to prevent the need to go to a hearing when, in the vast majority of cases, we already know that the outcome's going to be that they don't have the ability to pay because they aren't financial brokers or something like that. And that in those cases, either if there is some reason for the 4D program to know or for the custodial parent to know that this is one of those special cases, at least in a small jurisdiction like mine, we would know that we could actually ask for that in that particular case. But that's a pretty limited case.
This reminds me from a private practitioner perspective, this is the same problem we have with children turning of majority. It's the exact same problem we've got, which is you got a lot of parents who are desperate to get out of their child support obligation because their child's now an adult, and you've got all the confusion about whether or not we have to go to the court, not is it by operation of law. I think as a private practitioner, and Dawn, you may have a different, this is where we need that different input. I would prefer it be by operation of law, and then the ability for the court to go in and make an assessment of could they actually pay, should it stay in place, versus always having to run to the court on every single one of them, because I think it'll encapsulate a bunch more cases on the front end smoothly without a huge amount of judicial interference. But
if I can, Keith Pickard for the record, if I can just ask a question of our district attorneys. I'm wondering if from a practical standpoint, the by operation of law approach is really something that wouldn't it just come up in the context of somebody's all of a sudden not paying, they find out they're incarcerated, and then we do that retroactively? because I'm a little concerned about, the adjustment of support awards retroactively and the prohibition. But from a practical standpoint, I wonder if that's not how it's happening. If it's by operation of law, then arguably the day that person was incarcerated, the amount changed, and then we find out sometime later, oh, they're incarcerated, and so we go back and we suspend it as of that time. Isn't that how it works in practice?
So in practice, because we're proceeding to modify these cases through a motion to modify, there are no retroactive modifications, and the modification effective date is the month after the motion to modify is filed. So we are not always capturing the extensive period of time that respondent's been incarcerated. However, because of our interface, we're often catching these pretty quickly. But of course, you're missing a few months here and there. And then again, if they're in federal prison, we're missing large periods of time. My position is the same as Mr. Sanford. I would like to see this by operation of law.
I'm also in favor.
Dawn Throne.
Yeah, go ahead, Dawn. I'd like you to talk.
When you do that, Karen, do they send a notice to the recipient so that the recipient would be the one to know, hey, no, he really has residual income. He shouldn't get this operation of law exception?
Since we don't do it by operation of law now, the way we do it is through a motion to modify. Documents are filed. Both parties are on notice. Both parties have a hearing, and the respondent appears telephonically. But on those CCDC cases, we have our caseworkers go down to CCDC personally. But I don't know how California does it. By operation of law, I'm presuming no one's reaching out to the petitioner or the custodial parent.
Yeah, they just have straight up, it's operation of law, and then it says unless, and then it doesn't really say what happens on the unless part. If obviously it must be a hearing. I like the operation of law, but then I'm also in favor of language that's very similar to our mandatory language in our orders for Hague and for kidnapping, which is, hey, you have a child support obligation. If you're ever incarcerated or you're ever on TANF, which is part of that, you have to give notice or your child support will continue. I don't, if you're put on notice and it's in your order, that's one thing. If you didn't receive notice in your order that you have to give notice of it, then I don't know. They fly in the face of each other, though, being by operation of law versus saying there's a notice requirement, so.
Nova Murray, for the record, I think the most important part from the state perspective is that we have collectible child support. And when you're in prison and we know they can't pay it, we don't have a collectible order. So it doesn't help to have that order for us. And it actually makes us look bad that we have child support that we're not receiving and that we're not enforcing. And literally it's unenforceable on our side. And it takes us a little bit to figure that out. So it is a factor on our side for incentives and money coming into the state to have an enforceable order.
Do we have a motion? I'm just going to ask. I think we are crafting one, but specific on that issue of operation of law versus a requirement of a hearing. Do we have any consensus there? Because we're crafting a motion, but I mean that has to be decided too.
I think that if I've understood, it seems that we're all kind of leaning towards by operation of law, to the extent that once a person is incarcerated, their obligation would be suspended, that we would then put the recipient parent on notice that we've learned, and I think we can do this, that the individual who's incarcerated or their representative would put the opposing party on notice, whether that be through on a 4D case, through the DA's office, or in a private case, through their own attorney or some other means. They would notify the opposing party, and then it would be suspended pending an objection by the opposing party to come in and say, no, this individual has the ability to pay. That way we can, kind of tick off those bullet points. Did I state that accurately?
I think so. So if we summarize, the current motion is that we are going to craft language that incorporates the federal language that is required, that you cannot impute income. We're going to incorporate language, the Clark County language regarding suspension of child support and reinstatement using the California language. The one thing in the California language that we are for sure not going to use is no exception for domestic violence. We are going to have it by operation of law, but we're going to incorporate notice language regarding putting the recipient parent on notice of ability to contest based on the exceptions. And the only thing that I'm unsure on as far as this motion goes is where we sit between the 90 days and the 180 days. Don't know if we really got input on the 180. We got input on the 90, but I don't know that we got input on the 180 days.
Well, it appears as though the 180 is in the federal guidelines, so if what we're trying to do is stay consistent with the federal guidelines, then I don't know why we wouldn't go 180.
I agree. Additional thoughts on that? And then the only other thing I'd add to that is that I will volunteer, since I have the California language in my hands, to craft craft the language that this motion is proposing for presentation at our next agenda, or our next meeting on the next agenda, for us to actually look at it as written out. But for right now, that's the motion is to go in that direction in the crafting of that language.
I'll second.
Any more discussion? All in favor say aye.
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 Opposed say nay. Motion passes. No idea where my agenda is now. I lost it. Okay, we are going to move on to agenda item number 4D, discussion and recommendations as to whether the child support arrears policy on interest and penalties should be changed to, and if so, what they should be changed to. This is pursuant to item number 15 of Exhibit 44 of the Guideline Review. And do we have any discussion? Anybody want to start the discussion?
Keith Pickard, I'll start it. Personally, I've always thought that the penalties seemed a little bit unfair because not all cases were truly voluntary. Sometimes there were misunderstandings. Sometimes payment was made. For example, we were talking before we got started about direct cash payments. The payments were made, and I think it's unfair to add penalties in those cases. That said, I do believe that a party that has been deprived of the support should get the money that they came out of pocket with interest. So just as a suggestion, but not as a motion, I would lean towards eliminating the penalty as part of the calculation. However, I think that we should give the courts the discretion to add penalties if the non-payment was willful, and then to move forward with the interest on a compounded basis, not a simple interest as it is now, but compounded moving forward as those arrears accrue.
I would like to second Mr. Pickard's position on the penalty. This is Karen Cliff from the Clark County District Attorney's Office, and I would like to see penalties eliminated. Currently, the interest is set at prime plus 2. which of course, as we all know, could fluctuate. And I've been at the DA's office long enough to see sometimes it goes up to 13% or 12%. So my position is for us to possibly entertain maybe a flat interest rate. Thank you.
Okay, I'm going to pick it back up. I appreciate Ms. Cliff's support on the penalty piece. Unfortunately, I can't return the favor on the flat interest, if only because, the value of money changes every day. And I think that if we were to just arbitrarily pick a number, which is pretty much what we would have to do, we end up either underpaying or overpaying. I do like the idea. I know that from a practical standpoint, it makes it somewhat cumbersome. I know the spreadsheet that I created in order to do this it took me a long time because I had to go into each quarter, I think it's done on a quarterly basis, and figure out what the appropriate interest rate was for each period of time. But once built, that's actually a very easy thing to do. You just plug it into the spreadsheet, and fortunately most of those variations are dropping off. We've had 5.25% for a good long time, but I do think that following the variable interest rate, that CPI-driven interest rate, really is appropriate.
Ms. Murray, go ahead.
Nova Murray for the record. We're looking right now in the NRS. I'm not sure that interest was part of the NRS that we are supposed to be replacing. So in the event that interest isn't in the sections we're replacing, this would have to be addressed during session as a bill. I believe that penalties are correct. I thought so. Penalties are in the NRS that's being dissolved to look at, so we can determine to get rid of the penalties, and if we want to change interest, NRS.
Well, there you go. That narrows our scope.
Then based
I'm
upon
looking it up right now.
based upon the discussion, I would move that we do away with penalties.
Seconded.
I'd like to third that.
Any
Can I ask
discussion?
a question first?
Sure, go for it. Yeah, discussion right now, so.
What do we do if we say there's no penalty for future child support, but all these people who have penalty judgments that can't be changed? How do we do a fair enforcement if we just stop the penalties? But all these people who have existing child support judgments have huge penalties.
Welcome to the chaos of legislative change. It is what it is. We can't retroactively impact them. It's unfortunate, but I think this has been one of the things that need to be changed for a long time. There's examples, and none of the deputy DAs are speaking up right now, but there are some insane penalty cases out there that is 100 times what their original child support amount was. Just some crazy stories. So, all we can do is help the future. We can't help the past on that, unfortunately. Ms. Baker.
This is Kathleen Baker from the Washoe County District Attorney's Office. What Ms. Serrata is referring to is, in the past, I've talked to her about some of the cases that we've seen, but it hasn't just been penalties, it's also been interest. I had a case not too long ago where the principal was about $4,000, but given interest and penalties, this individual who was living on Social Security of $1,200 a month had a total owing of over $34,000. So that seems a little outrageous, and somehow trying to address that seems appropriate.
Okay, so right now we have a motion on the table to eliminate penalties, and we had a second and quote-unquote third. Do we have additional discussion? All in favor, say aye. Aye. Opposed, say nay. Motion passes. At this time, I say we table the issue of interest. We believe it's not within our purview, but let's confirm that for sure for the next agenda, just in case we can cover it. But that would be pursuant to the language of AB 278, and something we probably just overlooked in crafting AB 278, but maybe for legislative change in the future and outside of the...
Madam Chair,
Yes.
My apologies. Just for the benefit of the committee, interest is pursuant to NRS 125B 140 2C1, and the penalties are provided for in NRS 125B 095. So we'll have to go back into the text of AB 260 or 278 and determine whether or not we are we have properly repealed both of those sections. I believe we did, because I believe we repealed all of the child support calculation and penalty sections out of 125B, but we do need to look at that because it's a good point.
Nova Murray,
if
for
we
the
haven't
record.
addressed it,
Nova Murray, for the
if we
record.
haven't addressed it,
Hold
we
on,
do
one
need
at a time.
to
Yeah.
do so.
Okay, thank you, Mr. Picker. Go ahead.
We did not repeal 140. We did 80, 90, and 95. 85, I think, is in there. 070. We started at 070 and went forward. We did not repeal interest.
Okay, let's all take a look at that. I will put it
Madam
as
Chair,
an agenda.
for-
Yes.
Just, I think that may simplify things, because we were talking about maybe needing to address both, but we don't. If we just eliminate the penalty and we haven't modified 140, it stands and we're in good shape.
Exactly. Okay, so on under AB 278, the repealed sections are NRS 125. So under Section 13 of AB 278, the NRS sections that are repealed are 125B 070, 085, 095 are the exact repealed sections.
Okay, then 095 is the penalty section, and 140 does not need to be modified, or
Modified.
cannot be modified.
Cannot right now. For you to contemplate later.
Yeah, for the record, that might be
That's
something,
right.
when we wrap all this up, we might want to look at some of the things that we have discussed in these meetings, because we may come up with some really great ideas, and this would be a great committee to put legislation forward next session.
Okay.
And you're assuming anyone that's currently in the room is going to be reelected, but I agree.
Well, no, but I'll be there lobbying. All right, next section, next agenda item. We are moving on to agenda item number 5. Last time at our meeting, we had a presentation from North Dakota in which there was a discussion about how they have changed their review of child support orders to every 18 months instead of every 3 years in order to obtain right-size orders. I added this to the agenda because I was very intrigued by it and wanted to at least vet that through this commission before we lost sight of some of the input that came from the last meeting. Do we have any thoughts on that? In particular, I'd love to hear from the judges on changing the review from 3 years to 18 months. Judges.
Really?
Yes, really. I know it could potentially be more work, but I did ask him whether or not they had their judiciary behind it for the specific purpose of finding out whether or not it was a workload problem or not, and he said they were completely in favor of it.
Well, and I guess my position, and certainly Judge Robb can disagree with me, is that most of what my reviews end up being are 20% changes. Very seldom does anybody wait for a 3-year review, so maybe there would be more reviews if it was 18 rather than 3, but most of them are change of circumstance requests rather than 3-year reviews.
I completely agree with Judge Hoskin. My experience is at least 90% of what I see are change in circumstances. It's not just a simple 3-year review. The reason they're coming back, they're not going to take the time to come back to court just to see if it's 3 years. They know something, and they know that there's been a change, and that's why they're coming back. Or they suspect,
just
and they're
to add-
asking for the discovery.
And just to add to that, even the ones that I have that are 3 years old, there's still been enough of a change of circumstance that I would have reviewed it had it been less than 3 years. So I guess I can't answer whether 18 months would change that, but I don't think it'd be a workload concern.
Any other input? I just didn't want
If
it.
it ain't broke, don't fix it.
Exactly, I get it. We can move on to a different agenda item. I just didn't want it to, when certain ideas were heard from our presenters, I just didn't want it to drop through the cracks. So no motion on agenda number 5, unless somebody wants to make a motion. Yes.
I think the motion was that we stay pat at 3 years.
Okay, we can entertain that motion. Do we have a second?
Second.
Second.
All in favor, say aye.
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 Opposed?
Sorry, I was just a little late getting in. I'm presuming with regard to that, you're talking about the 3-year review or the change of circumstance review.
I did not mean to take out the change of circumstances at all. I just wanted the mandatory 3-year review to stay at 3 years, not 18 months.
Okay, good. I just didn't want to inadvertently do away with the change of circumstance potential.
Not my intent by the motion.
Okay, all in favor, say aye.
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 Opposed, say
Aye.
nay. Motion passes. Okay, we're going to move on to agenda item number 6, which is discuss and approve ideas for future agenda items. We have a few things that developed out of this meeting already, which obviously we're going to have the economic information to once again address action items from this agenda, particularly for A and for B. And also to include in the agenda is that 4C will come back on our agenda also once I draft up the language pursuant to our motions on incarcerated individuals for this, from this meeting. Additional agenda items to deal with next time. Yes, Ms. Baker.
Kathleen Baker from the District Attorney's Office in Washoe County. I've come across a lot of cases where parents want to agree to an amount that is not consistent with the formula, usually lower than that. I'd like to be able to entertain giving them the authority to do that, which when I was in California years and years and years ago, they could agree to 0, and I was surprised when I came to Nevada that they didn't have the ability to have that self-determination. So I'd just like to have that considered.
Okay, so we'll put stipulated modification of child support as the agenda item. Any other ideas for the next meeting? If we look at the chart that we have been working off of, the items that we have not addressed is, I'm looking, hold on. We have not specifically included on our agenda yet, and it may not be timed depending on what we decide on the other items, but we have not dealt specifically with agenda, or with Exhibit 44, items 9, 10, 11, 12, 13, 14, and, well, 16, but that'll be at the end of everything we do. So,
Madam Chair?
yes.
If I remember correctly, we discussed those as kind of the deviation factors, and we put them off not to come onto this agenda. It may be appropriate to at least put them on the agenda for next time, so that if we get a lot done, we can move on to them. But I still believe that since they're the deviation factors, for the most part, that we probably need to get the rest of this accomplished first.
I agree. That was a decision we made at a prior meeting, and I do believe I'll put it on the agenda just in case we get to them. Yes.
If I could just get clarification, Is this committee capable of, not capable, everyone here is capable of doing it, are we permitted to look at self-adjusting orders?
Yes, I believe we can. Would you like that as an agenda item?
I was thinking since we were looking at the modification, it just kind of reminded me of something that, provision that we don't have currently statutorily.
Okay, I will add that to the agenda. Any other items anybody would specifically like to add?
I don't know that we add it to the next agenda, but something that I have been asked by a Supreme Court justice to have us look at is these circumstances where we have either the Wright v. Osborne circumstance. I think they want that to be in statute, but also what happens when you have split custody. So
those are on the Exhibit 44 as specific items. One of them is shared parenting time, and the other was for adjustment for additional dependents.
Were those numbers, did I miss that? Were those numbers that you already had read off?
Those are numbers we have not covered yet, but that are on our to-do list out of that exhibit.
Thank you.
Yes.
Nova Marie, for the record, I think the adjustment for additional dependents, is that addressed in Wisconsin? Will that be something that we...
Wisconsin did have language for shared parenting time and for, I think our auditor called it serial parenting, was one of the phrases that was utilized. But yes, Wisconsin had some proposed language that a lot of us were keying into during the last meeting, and will probably be considered when we actually get to those items from the exhibit and use Wisconsin's language, or at least take a look at it. So obviously,
Madam Chair.
this commission needs to
Sorry.
go reread Wisconsin while it's at it, since we keep leaning on it a lot. But it had a lot of our missing items that we needed. Yes, Assemblyman
Madam
Baker.
Chair, that's found in DCF 150.04 sub 2, determining the child support obligations of shared placement parents. And then it goes on from there. It addresses them.
Okay. All right, I think we have a pretty fine-tuned ideas for the next agenda. I don't know that it needs any action. I'll just be taking that into consideration when I create the agenda. Agenda item number 7 is discuss future meeting dates. And I have asked, we sent out a list of dates just because I want to, instead of doing this one meeting at a time, I don't think that's good for any of us. I really think everybody needs to put it on their calendar and have it set out so that you can calendar around it. The input we received from the different commission members is that instead of looking at specific dates, we need to be looking at where more of a consensus is on which day of the week and then set the dates. Friday seemed to be a day of the week that got a lot more positive feedback from the commission. There will be Fridays that fall on actual holidays that we will not have access to this building or both buildings in order for the meeting to take place. Thoughts on Friday as the setting time for the dates. So the dates we sent out originally, the long list of dates were which day of the week? Tuesday. And so, and Judge Shirley and Shirley and Hoskin both were not available, and somebody else I think also had a hard time with Tuesdays, and Kathleen Baker. So if we take all the dates that we sent out in an email and fast forward it to the Friday after those dates, and use Fridays except for the ones that fall on holidays, do we have a consensus that that might work? Problems with Fridays?
Yes, for me.
No? All right, so I think right now I would make a motion that we set our meetings based on the schedule that was sent out, but fast forward it to the Friday of each of those, the Friday of that week. So, and of course it'll take place between 1 and 4. It will be contingent on availability of the legislative buildings and contingent on a change based on any of those dates falling on a holiday. Do we have a second for that motion?
Second.
All in favor say, or any further discussion?
The only question I have is we are currently setting without the people who can't be here because of this date. And I am concerned, for example, I know Justice Stiglitz has been unable to be here. I don't know if she's unavailable every Friday, and we might want to set at least a couple of our dates on a different day so she could be here.
From staff, do you know if you received input from Justice Stiglitz about Fridays? Okay, so the input off the record is that the greater problem with Justice Stiglitz was the short time frame, turnaround time frame, and not being able to block it on her calendar ahead of time. And I think that's pretty much what we're seeing. The only other input we received was from specific individuals who had specific calendaring issues. The ones that aren't here, I do not believe that it was an ongoing Friday problem for the ones that are not here. All right, we have a motion and a second. Do we all in favor say aye?
Aye.
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 Opposition, say nay. Okay, motion passes. Last agenda item is public comment. If we have anybody in Las Vegas that would like to give public comment at this time. Do we have anybody on the telephone that would like to give public comment at this time?
I would like to give public comment, please.
Okay, please, you have 3 minutes to give your public comment, and if you will start that with your name, please.
Sure. My name's Melissa Porter. I'm in Reno, and I spoke at the very beginning. And I'm just reiterating and requesting that you add to your agenda that in shared custody cases that are through the district attorney's office, that the district attorney actually send the employment verification forms to both of the parents' employers rather than just the quote-unquote non-custodial parent employers, so that it will give the actual correct income amounts and the amount of time that each parent have been employed with their respective employers. And that's it.
Okay, thank you very much. Do we have anybody else on the phone that would like to give public comment? Anybody in Carson City that would like to give public comment? All right, seeing none, we close agenda item number 8, and I would entertain a motion for adjournment at this time.
So moved.
Move to adjourn.
Second? Did we have a second? Was that Mr. Pickard?
Of course.
Of
Yeah,
course.
I'll second it. I'll third it.
All in favor say aye.
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 Opposed say nay.
Aye.
Aye.
All right. Thank you, everybody.
Thank you, everyone.